Welcome to the Floor Academy podcast. I'm your host, Kyle Hadeen, owner of Illustrious Hardwoods in always sunny Phoenix, Arizona. With me this week, I have, I gotta change the online stuff here. I got Joshua Turner with me, owner of Turner Law Firm in Gilbert, Arizona. We're going to get into some contracts here in just a minute. I want to let you know that Floor Academy podcast is here to help you change owning a job to owning a business to owning an asset. I want to help you build something that if you would choose to, you can walk away from. It's going to continue to run itself because contractors struggle in this business arena. We are artisans, great with our hands, and there's not always a lot of people talking about the business side of things, and that's what inspired this show. I want to have those conversations. I want to help you have those conversations and change your business. So, Joshua, who are you? What do you do? Why do you do it, man?
Yeah. So my name is Joshua Turner. I'm the owner and managing attorney of the Turner Law Firm based in Mesa, Arizona, with another office in the West Valley in Glendale, Arizona. I've owned the Turner Law Firm for 3 years. Prior to that, I was with another law firm in the West Valley. I kind of fell into not only business law, but construction law specifically. When I started working as an attorney, I was a family law and estate planning attorney. At least that was the plan. But with a small firm, you often take on other areas. Within a few days of starting at this other firm I was at, the managing partner decided that I would be great at handling a construction defect and breach of contract case that was well into the mid six figures. It was about halfway through the case at that point, and so I took it over, being a brand new baby attorney at that point in time, and took it to trial. The trial occurred about a year later. Whatever the reason is, you don't want to go to trial in civil court. Civil court trials can take 1 to 2 years or sometimes 5 years, depending on the complexity, before you get to a final trial. So hopefully we can talk about some tips to avoid that or get it settled before it ever comes to that point. I love being an attorney because it lets me honestly help people. I thought going into law a very long time ago that I would be a prosecutor. Turned that down and kind of went a different direction. Spent some time as a constitutional law attorney and constitutional scholar during law school, but then kind of fell in love with family law and business law. So our goal at the Turner Law Firm is really to provide kind of the basics that a family or a small business might need, whether it is family law representation, estate representation, helping startup businesses get going with whatever they need, or representing businesses in lawsuits and continuing that relationship. We do quite a bit of construction law. I just wrapped up a mid six-figure one not too long ago, where a lot of the stuff we'll talk about today will be pretty relevant.
Okay, I like it. You sound very passionate about what you're doing, and when I went looking for someone to discuss contracts and things with, you jumped out and you were like, "Hey, me over here." So, I'm happy to have this conversation. I think it's an often overlooked situation. We all think if we kind of write out a scope of work, or I see a lot of times on online groups, somebody's like, "Hey, who's got a contract I can look at?" And they might change the name of the company and a couple of terms and whatnot. And they put it to use in their area, but that contract came from Minnesota and they're operating in Utah. So how much of it is really legal? So let's start. When I initially got you on the phone, you're like, well, there's basics of what form a contract. So let's start at the beginning. And what are the basic necessities of a contract? And I know we're going to be talking, obviously you're licensed here in Arizona, and so that's your area of specialty. Some of this will apply to all states, as some things are just kind of universal, but just for the listeners, please go check with somebody local to your area. I know I have listeners overseas and other countries and whatnot. Check with someone in your area with anything you hear here. This is obviously more geared towards my area where I can reach out to people more easily, but some things are a little more universal and they just make sense to include no matter what, I would assume.
So definitely, I can only speak to Arizona law. That's going to be my point of reference for everything. If I may, Kyle, before we talk about contracts, I think the number one thing that a company can do to protect themselves is if you are currently working as a sole proprietor, go and establish an LLC. It is pretty straightforward to do. And the reason I say that is as a sole proprietor, if you are sued, and you may be, Kyle Heaton Flooring, but you're a sole proprietor. If you are sued, not only is your company, Kyle Heaton Flooring, liable, you are personally liable. And so the house you've been living in that now has a few $100,000 in equity, the 401k, the bank accounts, all of that can be taken as part of the lawsuit for the judgment. If you set up an LLC and handle it the correct way, don't commingle funds, don't pay all your personal expenses out of the business, you're not going to be held personally liable. The only thing that they can get after if there is a judgment against the company is the assets of the company. And so that would be my number one tip. If you're not an LLC, become an LLC. It's pretty straightforward and easy to do.
It is.
In terms of,
let me. I just put in the paperwork to the Arizona Corporation Commission this morning for Floor Academy. So my tax guy said that's not going to fly anymore. You got to get an actual LLC. You can't run it under the flooring company anymore. So the Arizona Corporation Commission, I know, has made it really easy. You go on the website, you put in a little bit of info, and it's all digital now. The first time I did it when I formed the flooring company, I botched it. They sent it back, and I had to pay the fee again because I filled out one little checkbox wrong or something like that. They didn't accept it, but it is really easy.
With that, if you are a sole member LLC, which Kyle, it sounds like you were when you started your flooring company, the forms are perfect to do because it's all you need. If you are going into business with a couple, even one other partner in an LLC, I would not recommend the standard forms. I would go to an attorney and have a formal articles of organization and operating agreement that covers how much each of you own of the company, your membership share, how dividends work, how disputes are going to be resolved. Because if you don't have that information, the default is your company gets dissolved and the assets get sold off. And so if you are a sole member LLC, the template forms work great. If you're going to do more than one person, you're going to want to talk to an attorney and have officially an operating agreement and the standard articles of organization.
Okay. Can I jump in? I think that's great. I know that partnerships are hard. They're almost harder than marriages, I think, especially like creating a child with your partner is one thing, but creating a business with somebody is a whole nother, and they're very similar, but it can almost be harder, and you spend more time with that business partner sometimes. So getting your ducks in a row through a proper agreement of how the business will function before you get into it, and how if you each own 50% and how arguments can be settled and which direction the company is going to go, it can save you a lot of headaches down the road.
Let me put it this way, and then we'll jump into contracts. You can pay my office, about $1,000 for the time to draft a solid, articles of organization and operating agreement. Usually they're about 15 to 20 pages, depending on the specific. So you can invest that $1,000 or so to do that. Or you can do the corporation commission form, save that money. And when stuff blows up, which inevitably it likely will, especially in business, you can pay an attorney. On average, litigation in the U.S. is $150,000 or more. And so an ounce of prevention, or you can do nothing and save that $1,000 or so and pay out $150,000 or more and potentially lose your business. When we talk about contracts, it's important to differentiate between, in Arizona, what is a handyman and what is a licensed contractor.
Okay.
What we're going to talk about is applicable to licensed contractors. The general rule of thumb is if it is a general project that does not require a specialty license, such as electrical, plumbing, HVAC, it can be done by a handyman if it is under $1,000.
Including materials.
Yes. Anything over $1,000, even $1,000.25, it is required that the contractor be licensed.
Mm-hmm.
If you want to use a handyman to install ceiling fans, great. If you're rewiring your entire patio for surround sound and it's going to be a $5,000 job, as a homeowner, do yourself a favor, make sure they are licensed. As a contractor, even if you are a handyman, try to get the contracting license. It is a test, a few months of study. It is pretty straightforward to get. You are protecting yourself a lot more by becoming a licensed contractor.
Yes.
When we talk about contracts, there's a number of things that state law requires to be in a contract for residential. And I will be honest, most contractors do not have this information in their contract. That at a minimum, the contract has to have your company's name and address, the name and address of the client, the exact scope of work that is being done. Simply replacing air conditioner is not going to cut it. You need to have the measurements, or pertinent to here, replacing the floor is not going to cut it. You need to have a breakdown. Demo of tile floor, this much. Replacement of, wood flooring, this much. Your material cost, all that needs to be included in there. You need to have the terms of payment. Is payment due up front in full? Is payment going to be on a monthly invoice? Net 30 that you're billing, is it going to be 1/3 down, 1/3 halfway through, and 1/3 at the end? All of those payment terms need to be outlined in there. You also need to have an estimated completion date in the contract. Even if that has to change, that's what our good friend change orders are for, but you have to have an estimated completion date. What I see most of the time that is not in contracts is in residential contracts, you are required to have language, and I believe it's in a minimum 13-point font, that the client has the right to contact the registrar of contractors and file a complaint. Not only do you have to say that they have that right, you have to provide the registrar of contractors' address and phone number. And the reason this stuff is important is if you do not have that in your contract, and it does end up going to litigation, under law, there is something called negligence per se. What it means is even though you did not intend to violate the statute, you violated that statute, and they are entitled to damages. What that means is attorney's fees. They may not have been damaged because you messed up the job by not having the contract right. For example, they may be suing you for breach of contract because the flooring was uneven. And that's one thing, and they may have damages for that. But then they look at your contract and the attorney says, well, they didn't have this, this, and this. That is a separate cause of action. And you may not have flooring damage or monetary damages from that breach for not having the requirements of the contract, but your damages are the attorney's fees.
Okay.
And so now, rather than potentially being awarded reasonable attorney's fees for breach of contract, it puts in play all of the attorney's fees as a damage for violating the state statute. It's, again, something pretty simple. I'm not sure if it's a lack of knowledge or lack of the ROC getting the information out there to contractors when they take the qualifying party test, or laziness or wanting to hide that information. But again, an ounce of prevention and having that language in there. We unfortunately are well past the days where we can simply say, I'm going to do this job for $5,000 and a handshake and we're good to go. The number one thing a contractor can do is document everything.
Agreed. Pictures, write it down, text, emails, whatever it is, put it all together. That brings up an interesting thing. So the ROC here in Arizona requires a 2-year workmanship warranty at a minimum. Whether you as a company want to offer something longer is up to you. But if let's say somebody has a problem at 2 years in 1 day, but that information about being able to contact the ROC or something wasn't in there, does that give them the ability to say the contract wasn't right and now they need to warranty it longer? Or is 2 years 2 years and they're still screwed?
Let's talk about the difference between civil court and the ROC.
Yes.
The ROC is going to attempt to make things right, either by making the contractor fix it or ultimately potentially taking it out of the recovery fund. The ROC is not going to award attorney's fees. So if you're a homeowner or a business, and you end up in an ROC dispute and you hire an attorney to handle it, let's say the flooring company is a prevailing party. They win at the ROC. The ROC says they did nothing wrong. They're not going to be able to recover their attorney's fees from the ROC, nor would the homeowner be able to if they were successful, because the ROC does not have statutory authority to do so. They're what's known as a limited jurisdiction tribunal. The ROC is basically, if you will, the prosecutor, and then there's a state administrative law judge that decides it if it goes to a hearing, and they're very limited on what they can do. And so if you are a homeowner, the best option is to go through the ROC if it can't be resolved to start. But if it's also a significant amount, for example, let's say there's a payment dispute as well, not necessarily workmanship, but they overbilled you. For example, if it was a cost plus contract instead of a lump sum, and the builder is saying, well, my costs were, $5,000 and, my 10% is this. Well, when the owner asks for receipts and shows that your costs were actually only $3,000, that may not be an ROC issue. That might be a civil litigation issue. So it is important to differentiate between the two. Obviously, we're talking far greater amounts in 2,000, which could be handled potentially in claims court. But the ROC is going to handle workmanship issues, breach of contract issues such as warranty, stuff like that are going to be handled in civil court. As to your direct question, the statutory violation of not having the required elements in the contract is not going to change a warranty deadline for the ROC.
Okay.
And the ROC would not do anything with the statutory violation. Again, that would be something in civil court. And so what we do, let's say that, just kind of walking through a case that may come in. If I have someone come in and tell me, whether it's and I represent both businesses and homeowners. So in this example, let's say a homeowner comes to me and says, Josh, I contracted, for X, Y, and Z to be done to my house, flooring as well as some drywall wall demo, etc. And the contract price was $50,000. The job is done, but they did a horrible job and they overbilled me. They did some change orders that were for their mistakes, and I ended up paying them $150,000 on what was supposed to be a $50,000 job. What I am going to likely start with is what's called a demand letter. And that demand letter is going to lay out to the business owner all of the claims that we have, whether that is breach of contract, breach of warranty, potentially negligent misrepresentation, breach of good faith and fair dealing, or if in a worst case scenario, potentially fraud, if we could show fraud. And that demand letter is going to come back with a amount to make this correct. Maybe we say we'll settle for fixing the damage, and 20,000 refunded or whatever it might be. And then the business is going to have 30 days to respond and agree or begin to do negotiations. And if we can't come to an agreement or they ignore it, after 30 days, the client and I are going to talk about the next step, which could be potentially both the ROC and a civil lawsuit. You could have both going on simultaneously, depending on the circumstances, or it could be just ROC, or it could be a civil lawsuit. Even if you have a defective workmanship issue, you do not have to go to the ROC. Me as a homeowner can go straight to filing a civil lawsuit for the damages that were caused. So it's important to remember, as a business owner, you kind of have dual issues you have to look out for. Not only preparing for the ROC, but also skipping the ROC and going straight to civil court if they felt it was appropriate. 9 times out of 10, it's going to go to the ROC because the monetary amount is not worth it to fight over in court, but that is always a potential. You're probably going to see more civil lawsuit stuff on the commercial side or in a significant TI in a residential.
What's TI?
Tenant improvement, if we're talking, or a remodel, something like that.
Okay. Makes sense. So just the job at hand.
Yeah.
Okay. No, and that makes sense. I mean, it's that in Arizona having the ROC, they're they're there for both parties. They kind of act as a third party mediator to
Yep.
settle issues, and it's generally residential stuff can be a lot, but it's not a lot. Whereas you get into some commercial stuff, and we could be talking millions of dollars, and so that's not something that they would generally be mediating over. It's going to be easier to jump right into that civil case and take care of it.
Yep. And the other important thing to note for business owners, going back to why they want to make sure they're licensed, if you are an unlicensed contractor and take a job that is over that $1,000, the ROC is not going to be able to hear the dispute, but they're going to refer you for criminal prosecution for contracting without a license. You're going to face the criminal charges, and then that homeowner is likely just going to go to civil court, because then that's their only remedy, is to sue you in civil court.
Yeah.
And when you are a company, you cannot represent yourself in court if you are an LLC. So you're going to be forced to go out and hire an attorney to represent the LLC.
Fun. That's going to be
Yes,
cheap.
and nobody wants to hire us.
Well, no, you guys are expensive.
Yeah. So that's the best thing, is the contract requirements. That's what's required.
Okay.
If we want to talk about some other good things to have in the contract,
Oh, yeah.
you're going to want to have an arbitration provision in there, that any disputes are going to go to binding arbitration rather than a civil lawsuit. Binding arbitration is a lot less expensive than it is to go to civil court. Civil court, like I said, you could face, a 5-year battle to get to a trial and 150 grand or more, versus an arbitration, which typically can be done within 3 to 4 months if you streamline getting documents exchanged, etc. And you're looking at maybe a third of the cost. For example, the case that I just wrapped up, it did end up being a $150,000 case that was decided by arbitration. But the facts of that case were such that both sides were ultimately asking for almost $1 million from each other. They were countersuing each other. So in a case like that, where you're asking for $1 million on both sides, if it had gone to trial, we could have easily been looking at a 2-week trial and maybe $500,000 on each side or more in attorney's fees, for doing that and getting it all the way through. Instead, we do a 3-day arbitration hearing, and the arbitrator issues a binding ruling, and we save the parties, on each side over a couple $100,000 in attorney's fees.
No, that makes sense.
And what's important to remember is, in a contract case, there is a potential for what is called the prevailing party to recover attorney's fees if you're successful, but it is never 100% of attorney's fees. It is what is known as your reasonable fees. And the definition of reasonable is left up to a judge. So also in your contract, what you can do is you can put in a provision that says, each side will pay their own cost of arbitration, and neither side will be entitled to attorney's fees. You can also put into the contract a damages limitation clause. When we talk about damages, there's a number of different kinds of damages. There's direct damages, there's consequential damages, there's punitive damages, which generally in a breach of contract case, unless it's fraud, is not going to apply. But let's talk about direct damages.
Okay.
Direct damages are those that, for example, if you mess up the floor and did not install it correctly, the direct damages are going to be what it's going to cost to get that floor fixed. Consequential damages may be, the loss of use of the house. If they have to be out of the house, for a long period of time, even a week or two, and incurred expenses for that. Those could be considered consequential damages. If they have to take off time from work to deal with it, again, consequential damages. Mm-hmm. So what you can do as a contractor, and again, the client may say, I'm not going to sign it, and you may revise it or whatever the case may be, but you can have in your contract that says, damages are limited to direct damages, and both sides are waiving consequential damages, punitive damages, etc. The other thing you're going to want in your contract is, if you are doing a net 30 payment plan, maybe it's an ongoing remodel that might take 5-10 months, and you're going to submit a billing request, a payment application every month. You're going to want specific terms in there about what that looks like. Is it due on the 15th? Is it due on the 20th? If you're a general contractor, you better be familiar with the Arizona Prompt Pay Act. The Prompt Pay Act, I find a lot of people are not familiar with, but it is hugely important. The Prompt Pay Act requires a homeowner to approve a bill from a contractor within 14 days or 7 days. And then after that 7 days, they have 14 days to pay it. If the homeowner does not dispute the bill within 7 days, it is presumed that the bill is valid. So as a general contractor, if you submit your bill on the 7th, the 14th comes along, the homeowner has not said, that there's anything wrong, they now have until the 28th to pay you that payment. Mm-hmm. If they don't pay it by the 28th, on day 29, they have violated the Prompt Pay Act. And what that means is that they are now entitled to interest, the general contractor is entitled to interest at 18% per year. So that can add up very quickly. The flip side of that is, as a general contractor, you do not have to pay your subcontractor until you are paid by the homeowner. What the Prompt Pay Act says is that you have to pay your subcontractor, again, within 7 days of being paid by the homeowner. So there's a lot of stuff that is important to know. We could go on for hours with the Prompt Pay Act, but those are the basics of that. To modify the Prompt Pay Act, you have to have it explicitly written in the contract. And so the terms of payment are huge. If you're going to charge a late fee or late interest, that has to be in there. You, again, can put in whatever you want, whether it's $25 late fee and 18% interest, you can have that as your standard default for late payments, but you have to have it in the contract. You also want in your contract what is called a severability clause. And what that means is that if there's a portion of your contract that the court says, no, this isn't going to fly with state law. If you don't have a severability clause in there, then the entire contract gets thrown out as unenforceable. If you have a severability clause in the contract, just the portion that the court says is invalid gets thrown out, and the remaining contract stays in effect. Laws change, case law changes. So let's say, practical example, you have in your contract that there's a 15% late fee every month that is applied. Mm-hmm. And they don't pay, you take the homeowner to court. The court says, well, the law's been changed and you can now no longer charge more than what the prime rate is. Prime rate is 8%.
Okay.
So if you do not have a severability clause, because that one clause about the 15% interest rate is no longer enforceable, your entire contract gets thrown out, and then it goes up to the court to try to decide what is fair and equitable. Versus if you have a severability clause in there, then just the interest portion gets thrown out and rest of the contract remains. Mm-hmm. The best thing a business owner can do, again, going back to the same example with drafting an operating agreement, is have an attorney draft your initial contract. Again, you're probably looking somewhere between, depending on the specifics of your business and what you need in there, maybe $1,000 to $1,500. Okay. And then you own that contract and you can change it or have the attorney change it, but you can put the names of the client in there for each and every one. That way you are protected. I see a lot of companies that want to try to do it on their own or use a document preparer. A document preparer or LegalZoom, any of those things cannot offer you legal advice. All they can do is give you a document that is responsive to what you have told them.
Okay.
So again, if I had a theme for what I wanted to share is an ounce of prevention.
Yes. No, I think that's it's funny in that we spend money on tools, trucks, trailers, all the fancy things, and yet we won't do something that'll help protect us. Keep it all.
Yeah,
it's absurd. And I'm not one to talk. I don't have a contract. I'm missing some of the things you're talking about. It'd be easy to add in basics, but I've had a lawyer on in the past, and I know it's something I need to get done because I've had things that have come up, and it's not fun to start thinking, okay, where is this going? How am I going to get out of this? What's going to happen? Because I know that all these things aren't in place, and I don't want to spend that kind of money.
Yeah, and I will tell you, Kyle, for you and the other listeners in that situation, there are options. Nobody wants to hire an attorney. I get that, but it may save you the money in the long run. And, something that we like to do, and I'm sure there's other firms that do something similar, but we love coming into a company and being their general counsel. That doesn't mean you're always paying us. You're not going to pay us a salary. You're not going to pay us a monthly, retainer fee that, even if you don't have work that month, that you're still going to pay us.
Yeah.
Some firms do it that way. We don't. What we do is you have a security deposit, basically your retainer, but you're only charged and actually billed when you need us. Maybe it's a quick 5-minute phone call one month that you're billed for, just to answer a few questions. Maybe the next month it is reviewing some contracts or employment issues, stuff like that you may not think about. Now, I'm a small business owner myself. When I started my law firm without a plan, I've been where you were and are to some degree.
Yeah.
I left my firm intending to take some vacation and then go to work for another firm. My clients had different ideas. And so I found myself, okay, I have 30 clients that want me to work on their cases. I need to figure out what I'm going to do. So I opened up the Turner Law Firm in 48 hours. And I quickly learned the one thing that they don't show you in law school or probably in trade school
is how to run a business.
You know your area of expertise well, but you don't know, how to run a business. And so it is the same way. I quickly had to surround myself with experts, to help me run my business, a CPA, a bookkeeper, all of that kind of stuff. And if you want to be successful, that's what you have to do. So we love helping startups or established businesses, get that framework in place. It might be an investment in the beginning, but that investment's going to pay off because then you're protected and you're set up for success.
Yes. No, I 100% agree. I think it makes sense to. One of the first things I did was hire a bookkeeper. Was it a lot of work? No, but it was enough that I know I didn't want to do it. That's not my area of expertise. I'm a huge proponent of go spend the money on the expert, because if you free up that time, then you have that time to invest in working on your business, hopefully, instead of in it, and you can grow it and go get the next project, find a way to be more profitable, whatever you need to do. So it's easier for me to go hire you to make a contract than me spend the next 2 years reading law books so that I can get it right. That's just not a wise investment of time.
And Kyle, that's the thing. And I love working in, construction law and helping folks there. The one thing I see more than ever in the construction field versus other areas of law is a pride and arrogance. And I don't mean that disrespectfully. But sometimes as contractors, you have to set aside your pride, maybe admit that you made a mistake, but also admit that you don't know everything. In the age of Google, it is easy to get your law degree from Google. That law degree is worth what you paid for it. Yes, you can go online and find a template contract for, a flooring company or an HVAC company. Here's the problem. It probably has nothing to do with Arizona law. It's not going to tell you what the requirements are that you need to have. And it's going to probably get you in more trouble than the 15 minutes you spent researching it. And it's going to cost you a lot more money than being the free template.
I agree. It's definitely not a road I would want to go down. So, as I said, the money is always well spent. And I think that's the biggest key takeaway here is, as you said, an ounce of prevention is going to go a long way. So yeah, you may not have the extra $1,000 or $1,500 to have someone make you up a contract right now, but start saving it, right? If you can get a couple $100 a month, guys and gals, do it and buy it when you can get it. Like you're probably going to be okay. Don't take my word for it. Things happen. I get it, but most likely you'll be okay until you get it, but you need to get it because you're doing things that cost too much money and you don't want to be on the hook for them. I mean, granted, you should be saving up money to be able to replace any job without having to wait on your insurance company to say it's okay, in my opinion. But, it takes a minute to save up 20 grand, 30 grand into an account that you can just let sit there just in case. There's a lot of contractors that work project to project, paycheck to paycheck. And so that's what I don't want to see, is that if you're in that situation, something as dumb as a contract going south absolutely ruins you.
And there's a lot of practical tips outside of, the contract documents that we can talk about, as we go on, that will help you potentially prevent a lawsuit. But if you do get into a lawsuit situation, they will save you, and these tips are highly important.
Okay. I got to interrupt us 1 second here, and then we'll jump right back into it. Hey, listeners, whether you're an installer, retailer, distributor, or serve in another capacity within our industry, attending trade shows is a solid resource to expand your knowledge and networking base. You can also learn about the newest and industry-leading products coming to market. The International Surface event is returning to Las Vegas January 31st through February 2nd, 2023. So mark your calendars right now. Floor Academy podcast listeners will have exclusive registration offers coming soon. Stay up to date with the International Surfaces event page on Facebook. Johns Manville manufactures a range of innovative product. Oh, okay. Here we go. Johns Manville manufactures a range of innovative building materials, including products for the flooring industry. From GoBoard to Evolith, Johns Manville products are not often visible, but they provide technical, environmental, and economic advantages to the essential items you are installing every day. GoBoard is an ultra lightweight, waterproof tile backer board, and Evolith products are fiberglass or polyester non-woven components used in making carpet tiles, LVT, and resilient flooring. All right, Joshua, what are these? Where are we going? What are these tips? What else are we looking to include, save ourselves, and definitely keep us protected? And this isn't a one-sided thing. As much as it protects us, I'm sure it's there to help protect the client as well.
Absolutely. So, number one thing, document everything. And when I say document everything, don't use text message. The reason for that, your phone may fail, your messages get lost, etc. Mm-hmm. And it is just easier to have your records compiled in one place. For example, the big case that I just wrapped up, about 3/4 of the way through the case, the client was, and this client was a general contractor, said, "Hey, where are these documents I sent you? Why aren't we talking about them?" And I said, "What are you talking about? What documents?" "Well, we sent you all these emails and text messages." And I said, "No, you didn't." And come to find out, he did not send them. And these were documents, good portion of them text messages, that could have, resulted in settling this case months prior and thousands less in fees. And so every project that you take on, whether you are using a hard file, system or an electronic file system, mm-hmm. Have a file folder for every project. In that file folder should be your contract, your bids, your, order forms, for all your subs, if you're doing subs, material purchase, etc., and any contact with the homeowner. If the homeowner comes and says, "Kyle, we've decided we want to, add the upstairs too. New change order, new contract." Mm-hmm. Tell them to put it in writing that they want to do this, and make it via email. That way it's easy to track. You have it. It's probably not going anywhere. Next tip, change orders. Change orders are big in the construction industry. We need to know and understand what change orders are for and what they're not for, and what we do with a change order. A change order is not there because you did not estimate enough grout, or you did not estimate enough drywall mud. That is on you as a contractor. If you run out of drywall mud halfway through, guess what? That's eating into your profit. As a flooring contractor, if let's say that you remove the floor and you see that underneath the floor there's a lot more work that's going to be done that was on no. That is a valid change order.
Yes.
Running out of grout, again, not a valid change order. Do not do the work. Do not proceed until a change order is signed by a client. I know in the construction industry that is difficult. People want it and they want it now and they don't want to wait. I have a lot of clients on both the homeowner and the contractor side that say, well, we verbally got permission. We said we'd fill up the documents later and do it. You are asking for a world of trouble. And change order, let's say that they decide, Kyle, I'm using flooring a lot.
Yeah.
Let's say they come to you and say that they want a different color flooring. Guess what? That's a change order.
Yes.
Even if the cost is the same, but they just want a different color. That is a change order and should be documented as such, because it may change, other parts of the job. The grout color might change. If it's tile. It may delay the job and extend the time because now you have to get a different one ordered, stuff like that.
Yeah.
If there is a change order, a change order should also be done if you need more time for the job. Your contract provides an estimated completion date. Stuff happens. If there's a reason that the time needs to be extended, such as the floor needs additional changes, then that's a change order. And you put the new estimated completion date and the number of extra days in the change order. Let's say it's something simple, though, where you got sick, as a contractor, and you need more time and the homeowner is fine with that. That should still be a change order to protect yourself. Because if it's not, and there is a time is of the essence clause in the contract, that is what's going to control. And the homeowner says, well, yeah, you told me you got sick. I tried to be understanding, but you didn't have the job done when we agreed. I'm coming after you for damages. That simple change order that says an extra 5 days because I got sick is going to save you.
Well, I heard of a lot of problems with that kind of stuff coming up when all the supply chain issues came about, right? These home builders can't get homes done. And they were told that, hey, you'll have your home in August. And now it's March of next year because they weren't able to get everything done and people are freaking out. And so, like you said, right, there was originally a date and there was probably some term in there saying like, this is what's reasonable and you're entitled to compensation if we don't finish it on time. And if the changes weren't documented, if, I don't know if that's considered an act of God or whatever, but there could have been a lot of companies that went broke over that situation. Yeah.
And as the company, you are the one being hired. You are the one giving them the contract. So the contract is designed to protect them, but it's also designed to protect you because you are the drafter of the contract. You are the drafter of the change orders. The homeowner is not going to know what a change order is generally. They're not going to know, in terms of, oh, okay, well, this is what this is. It's your job as a contractor to do it. And if you don't do it, it's going to open you up to that liability. The next thing you do, document. And again, in terms of prevention, document and provide evidence. Pictures before you start the job. Pictures, maybe once a week or halfway through. Logs. And this not only applies to a bigger job like a commercial job, but even, a residential job. If you're going to install a floor and, do some other stuff and it's going to take, 2 to 3 weeks, every week you and your team should be, drafting an update. This is where we're at with the project, supply it with pictures. That way, if it does come to litigation, you can show I did this at this stage, this at this stage. This is where it was when talks broke down or whatever it may have been. And so you can protect yourself. Again, that in the big case I keep referencing, excuse me, in the big case I keep referencing, that is what ultimately saved the client is that they had, easily thousands upon thousands of pictures documenting where they were at specific points of the job, because one of the claims was that they didn't do a lot of the work.
Okay. Let's, so my question would be is I'm installing the floor. I work by myself, even if I have a crew. Let's say I'm on a larger 2,000, 3,000 square foot project in a nicer home. I'm not going to get that all done in a day, right? It's going to take me maybe a few days, a week to fill all of that space in. So the homeowner decides they still want to live in the home. They're going to shuffle their stuff back and forth. I haven't completed the job, but they're moving furniture all over so that I can keep moving along. They scratch a section that's already done. Is that on them or is that on me?
That is absolutely on them.
That's
You know,
what I
and
would
that's
assume. But
yeah.
well,
And
you're not
that's
done
again where
yet.
the business come in, and document that. So for example, Kyle, I'll tell you, I've asked you to give me a quote to do some flooring in my house and in all
Yes,
this.
correct.
And I will tell you, we're going to have to go, luckily it's only downstairs, nothing upstairs, but we live in the house. My family, my two kids, my two black labs. We're probably going to have to move stuff from one room to the other. Now, I know I'm not going to move it until you give me the okay. But, you would be well advised, not that I'm going to be one of the normal people out there, not normal, but maybe the exception to normal, that, scratch it and blame it on you. But again, the general contractor, the normal contractor is going to want to take photos. So if you're leaving at the end of the day and the room has no furniture in it, you're done with that room, take photos of the entire room showing nothing in it, that the flooring is perfect. When you come back in the morning, if there's a scratch on that floor and there's now stuff in the room, again, document it.
Look, you can't over document anything, folks. That's for sure. So this is about covering your butt in this situation, and that's what this is your business, this is your livelihood, this is what you need to be doing to stay ahead of the curve. People suck, okay? We'll just throw that out there. People suck, and some people want to get ahead off somebody else's misery. So it's in your best interest to do the little bit of extra work, especially with camera phones these days. It's not like you're having to go and buy a roll of film and get it developed. You have a phone in your pocket on your cell phone. You can take as many pictures as you want. What Joshua was saying about, you've probably got a file on your computer that has the contract in it, the bid in it, whatever. You drop those photos in there, and you make sure that you have an offsite hard drive that these things get backed up to, so that you have, 2 copies. So you got one, if something ever happens to your house, they're offsite somewhere and they should be protected, and you can reference them. And there's always that thing to go back to. And a lot of times, and Joshua, tell me if I'm wrong, it becomes he said, she said, right? It can be a very childish game of, well, they said they were going to do this, and well, they did that, and here's the evidence.
And that's where and exactly. And I'll tell you, just for an example from my field as a lawyer, if contractors think they are overregulated, try being a lawyer. When we talk about documents and client files for a law firm, not only is it the documents that we submit to the court, maybe pleadings that we're working on, that, letters to the other attorney, etc. It includes all that, but it also includes any email the other attorney sends me, any email the client sends me, any text message the client might send me, which is why I say stay away from text messages. It just makes it a lot harder. It also includes, if I'm sitting in a client meeting right now and I'm taking notes, about what the client is saying so I can draft documents, those notes are part of that case file. And at any time the client can request in my field any of that information. So we have to track every email, every text, every phone call, every document that we work on, every document that we file, anything that comes from the other side. But that also, even though it seems strenuous and does take a lot of time, it is also what protects me, and what will ultimately protect you. So you make it easy on yourself and say, we're only going to do email communication rather than email and text, and it has to be in writing, and you tell the client up front, and then it's to protect both of you. If they want something different, ask them to put it in writing. Or if they tell you it verbally, that's when you get the change order out and you write it down and have them sign it. And you tell them, hey, this will be a change order. When I'm back tomorrow, I'll have the change order and the pricing. And in the change order, include the documents to back up the pricing. So if they're wanting an extra 5,000 square feet of laminate flooring, you're going to come back not only with a change order that says the price, you're going to come back with the documentation to show that the laminate flooring is going to be this much, and then you put on and you break it out between labor cost and your, material cost on the change order, and you back up the material cost, because that's going to protect you in the long run. And ultimately, you don't want to hide that. If you're doing a cost plus, you're going to get your 10 or 15% on top of the material. So you want to be honest with the material. If you're doing a lump sum, same thing. If you are a good contractor, you know how to estimate a job, and you know how to build that in with your profit and what may come up that's unexpected.
Yes. And that's your area of expertise, so you got to knock it out the park. I would add in that I just saw a post in one of my online flooring groups, and somebody was like, my client keeps contacting me in text and calls and emails, and if they call and I don't answer, they immediately send an email saying, hey, I tried to call and da da da, and they're like, I just want one form of communication. So how do I do that? And I think you could put that in your contract that, hey, once we start, all forms of communication need to be made through email, or if you call me, right? Like, I think even if the client calls, you should probably be documenting that conversation after the fact. Send them an email just to make sure that conversation's documented somewhere, that you agreed to X, Y, and Z, and they can, tell them, hey, I need a reply back that this is, what we went over.
Kyle, what you're getting into is great, because it's also my next point is managing expectations. If you tell, feel free to tell your client that you have other jobs going on. It's not going to hurt you, but what it's going to do is you say, Mr. Turner, we have these projects going on. We're starting yours tomorrow. My crew will be here at this time. I will be touching base with them. I'm your point of contact. But please know that, if I'm not able to answer right away, I will get back to you in 24 hours or within 72 hours, whatever that may be. Mm-hmm. Mm-hmm. And set those expectations so that they know. Because we live in a world right now where it's, I want it and I want it now.
Yes.
To quote a famous young lady from Willy Wonka and the Chocolate Factory. And if we don't set those expectations that it's going to be 24 or 48 hours, it's going to piss off the client and just lead to a deteriorating relationship. And even beyond, litigation or lawsuits, at least in my field, and I'm sure in the construction industry as well, the number one way we survive is referrals.
Yes.
I can tell you personally, we invest very little in advertising, but we are very successful because of referrals. 90% of my business as an attorney is from people that have been referred to me. And I will tell them up front, I don't want you as a client to hear a horror story from my firm that you may from some of the other firms where you hear people say, I called my attorney 3 weeks ago and they still haven't gotten back to me. It is my firm's policy that if myself or my head paralegal is not available when you call or email, we will get back to you within 48 hours. And we stick to that. And we tell the client that going in so they know what the expectation is. Mm-hmm, mm-hmm. What I hear right now, and it's all over Facebook and different groups or wherever, is contractors that are ghosting clients.
Yes.
And it may be, well, they came out and gave me a bid and I told them I want to hire them. I've never heard from them before. They came out, did the estimate, said they would email me the bid and never heard from them. I get it. It's hard to find employees right now. Some clients can be very difficult. They want everything and they want it right away, but managing expectations and telling them up front, it's going to be, give me 48 hours to get you that estimate. Yeah. Again, you're managing expectations. You're making the client happy. You're holding yourself to it. That's the type of stuff that builds relationships, prevents issues, and hopefully avoids a lawsuit. Because let's say that you do that kind of stuff up front. You have that open communication, and later down the road, there becomes an issue. Rather than setting the homeowner off and potentially jumping right to, you're fired and threats of lawsuits, they're going to be more willing to work with you because they know that you're reasonable. They know that you're going to try to make it right. And they know you're going to communicate about it. Mm-hmm, mm-hmm. Oftentimes what I hear from my own clients as contractors is as soon as a homeowner or a client, mentions a potential issue, they get very defensive. Well, I've been doing this for 30 years. I know what I'm doing. They don't know. You've got to get rid of that mentality, both from a customer service standpoint and a protecting yourself and your company from a lawsuit standpoint.
I agree. I think communication is huge, and those complaints aren't just... It's sad. I've won tons of projects because they're like, well, you're the only one that submitted a bid. You're the only one that showed up when you said you would, right? Like if I tell you I'm going to be there at 8:00 to do a bid, I'm there at 8:00 and making it happen. it's little things that can set you so far apart, but they're really standards of business. And once again, this goes back to contractors are great artisans, not always so great at the business side. And so I don't even think it's that they're ghosting them on purpose. They're just so busy and they lose track of stuff, and that's not their area of expertise. And
exactly. Homeowners can definitely give the benefit of the doubt as well. I'll tell you a personal experience. Prior to where I'm at now, I lived in the West Valley, owned a home that, in the hailstorms of, I believe, 2017, the roof got pretty damaged. And insurance told me, yep, you're getting a full roof replacement, find somebody. And so after a bunch of calls, I hired a company that had decent reviews, thought was pretty good. They told me they were going to be out there Monday at 7 a.m. I took the day off of work just to make sure that they, got going, make sure everything was going smoothly. 9 a.m. comes, no phone call, no workers. 1 p.m. comes, no phone call, no workers. And so at that point, I'm like, all right, I'm going to call the company.
Yeah.
Call the company. The owner tells me, well, my crew didn't show up to meet their foreman and go to the job site. I don't know where they are. We might, maybe we can start tomorrow, maybe the next day. I don't know where my workers went. I'll have to let you know. At that point, it became, no, you're fired.
Yeah.
Return my deposit. Well, they returned the deposit, but the check bounced. And so they had bigger issues than that. Mm-hmm. But my point is, had he called me at, 8 a.m., even 9 a.m., said, hey, whatever reason, we're running a little bit behind. We're not going to be able to make it today. We apologize, but we will be there tomorrow.
Yeah.
They probably still would have had the job.
Mm-hmm, mm-hmm. No, it's silly how, once again, an ounce of prevention goes a long way. Just communicate and be open. Honestly, I was doing a removal job and I had to pull the fridge out and I was busy talking and not paying attention. And so I was talking to somebody that was helping me move it around and I put it into the wall. And so I dented the corner bead on the drywall, and I said, oh, shoot, took a picture of it, sent it to the owner, said, hey, I did this. It's on me. I'm happy to pay for it. When she's out of town right now, I was like, so I know that I won't get a bill for a long time, but I know you're having the room painted. So once they get around to fixing it, let me know how much it is. And I will, I'll cut you the check back. It's own it. Just own it. Look, we all make mistakes. We all have things come up. We're all human. We're dealing with other humans in our businesses. Just talk about it.
Yeah, so I think the last thing, the other best tip I could provide, is obviously we talked about documentation, talked about communication, and the next tip is insure your company. And yes, insurance can be expensive, business plans, depending on how much you want, it could be expensive. Here's the reality though. If you do not have insurance and somebody files a lawsuit against you, same way with auto insurance, homeowners, etc. If you don't have that insurance, you're personally liable. B, you have to hire and pay for the attorney. If you have any sort of professional malpractice insurance or negligence insurance as a contractor, and a claim is made, the insurance company is going to pay that claim up to the policy limits. The other advantage is if it does go to a lawsuit, guess who's paying for the attorney? The insurance company. Yes, you might see a rise in premium, but it's going to be a lot lower, less rise in a premium than if you had to hire your own attorney. And so I have that liability insurance for your company. It's another easy way to protect yourself and invest in your company and not lose everything.
Look, it's cheap. It's called just in case for a reason, right? It's insurance. So you build it into your rates, folks. And if you don't know how to do that, you can go to flooracademypod.com. You can click on the file section, go get my business budget calculator, and I will help you with that tool build in all this nonsense into your, what you need to make a day. So you have to be able to run a profitable business. You have to be able to afford insurance and being licensed in your state if it's required, and carrying the the bond, whatever's needed. You need to be able to replace your truck, your tools, all that stuff. And so that's what this is about, is making sure you're protected and those things are happening. Before you were talking about with the change orders, like don't do the work until it's signed. And that's really hard because a lot of times homeowners are offsite or whatever. All the phones now have a feature where you can add a signature because they have a touchscreen. There's no excuse not to be able to get a signature quickly. You can email it off. You open up the app and you can edit it. And there's like the little pen with like a squiggly underneath it. You click on that and you can make your signature right on the phone. They can edit it, save it, and they email it right back to you. So
yeah. And the reason I'm adamant about change orders and not doing the work until it is signed, let's say you have a $50,000 change order, even 10,000. Whatever the amount, the owner says, yeah, go ahead and do it. I'll sign it tomorrow when I see you. You do the work, then they say, no, I'm not going to pay you. There's no change order.
Mm-hmm.
You have no contract. You might have some legal theories, under unjust enrichment or stuff like that, but you have no contract with them for that work and the payment. And so do not proceed to protect yourself until you have that in writing. The other issue is, maybe you do it verbally. And this came up, in my last case. And I have had a come to Jesus moment with my client because he's still my client. And he's a general contractor. But in that case, what happened was, the opposing party said, well, no, you told me verbally and what we agreed on was, 50,000. But now you put in this change order that it was 85,000. And so you have a huge dispute there over what is actually owed.
Yeah.
And again, talking about the nature of change orders. In this case, one of them, the owner expected that the price should have included asbestos abatement. There was never any asbestos inspection done until after the job got underway and demos started. Obviously, as a contractor, you cannot know whether there's a building that actually has asbestos or not. Yeah. That is a valid change order. Luckily, that was one of them that the other side had signed, so no issues. But again, if he hadn't signed that, my client may have been eating that money and not successful in court.
Mm-hmm, mm-hmm.
And if you're running decent profit margins and not padding your bill and overcharging your customers, you can't afford to eat $5-10 grand because you didn't document the paperwork correctly.
Exactly, and you shouldn't be. It's not. It's a pain to do it right. I get it. I get it. Trust me. It's a pain to do it right. However, it's worth the extra minute to go and write up the change order. Look, if you got to scribble it on a napkin, it's a binding contract once it's written up and signed. So you can always make it look pretty at home and have them sign it again the next day. But go out to the truck. You got to have a sheet of paper. You probably, knowing what most contractors got going on, there's probably like going with stereotypes, right? You got a bag from some restaurant on the floorboard of your truck. Like, go grab that and write it up on the back and get it signed and make it happen. There's not an excuse to lose this kind of money because you were feeling lazy and you want to feel good about being able to do a good old boy handshake and move on with your life.
And here's the reality. Most contractors are familiar with the AIA, the American Institute of Architects, or whatever it stands for, I forget. But they have template documents for contractors. One of the templates is a change order. That is perfect because it talks about the work, it talks about a new completion date, and the number of extra days that are added into the contract. Even if you have an attorney design a change order for you specific to your field, print out a stack of them, keep 5 or 10 of them in your truck. And that way, if you're able to look at the prices from the phone while you're there with the homeowner, look at it, write it up right then and there, have them sign it. And worst case scenario, you have the hard copy printed, or you send it electronically, like you said. But there really is no excuse not to have a proper change order with you as a contractor.
Okay. Especially if there's if you can get it online and there's a, resource to have it. Technology has made our lives so easy that we've become even lazier, which is sad. we need to get over it. You're running a business. You have to be responsible. This isn't playtime. This isn't I get to go and be Chuck in a truck anymore. We've got to take this seriously. There's thousands of dollars on the line.
Yeah. And I think the last thing, Kyle, that we talked about and you asked me to talk about is what happens if you do get in a lawsuit or a complaint?
Yeah.
If you get, if the homeowner starts making noise and says, I'm hiring an attorney, at that point, you get your attorney or your insurance company involved. And the reason for that, especially in the insurance side, if you know of a complaint that has been made or, a charge against you, if you will, by, a homeowner, or if they have an attorney call you and you don't get your insurance company involved right away, you try to handle it on your own, the insurance company could come back and say, no, we're not covering you because you didn't alert us within the time frame that it happened that's required by the contract we have. Even if you're not going to submit it to insurance and you're going to try to handle it yourself, you still need to have an attorney do it. And the reason for that is, it takes the emotional component out of it. We may be willing to admit we made a mistake, but oftentimes we don't like to admit, a big mistake or the extent of it. And we definitely don't want to part with what we believe is our hard-earned money. By getting the lawyer involved immediately, it prevents you from doing something stupid, such as making an admission. Yeah, I screwed up on this. I'll pay you back. Even if you want to be a good guy and say, I'll give you $500 for this, and they're demanding, $10,000, or you say $5,000 and they're demanding $10,000. By you saying, even if you didn't do anything wrong, but you're trying to be a good guy and just take care of it, again, under the customer service mantra, by you saying, I'll give you $5,000 and they're not happy and they go to a civil suit, you've admitted liability by saying you would give them $5,000. And so have an attorney there from the outset, because what that attorney is going to do is say, okay, here's what the documents say. Here's what they're claiming. Here's what we need to settle this and get it resolved quickly so it doesn't go to litigation. Here's what your liability is. Or no, this is a solid case that you have and they have nothing, so we defend it. An attorney is going to be able to keep you from shooting yourself in the foot, putting your foot in your mouth, and making things worse. If I have to, as an attorney, come into the middle of a case, well, guess what? I have to now review everything that you've done prior, and it's going to cost you a lot more.
Yeah. Go ahead.
So once you get, a customer saying, I'm going to hire an attorney, that's your key right there. You say, okay, here's the name of my attorney. Have them contact my attorney. And you cut off contact with them. If the job is still ongoing, you say, well, I would like to complete the job. Are you going to let me complete the job? Again, in writing, because you want to make sure you're upholding your end of the job. If they tell you, no, you're not going to complete the job, you want that in writing to protect yourself. If an attorney calls you, immediately, no, sorry, I'm not going to talk to you. Here's the name of my attorney, or I will be retaining an attorney. They'll be in contact with you. Do not, just as, you have a right to remain silent with the police, the attorney cannot force you to talk to them. Don't try to outsmart the attorney. Even the dumbest attorney, and there are a lot of them, even the dumbest attorney has a greater understanding of the law than a non-lawyer.
That makes sense. You bring up a good point of the trying to settle and be like, well, I'll give you 5 even though you want 10, and that's an admission of guilt. A lot of times I see people saying the client doesn't want to pay to have the floors flattened. They don't want to do this. They don't want to do that. They don't want to fix whatever issue. So I just have them sign a waiver. And yes. I've always been taught that a waiver is just an admission of guilt. And if this thing goes to court because the floor fails, like I said, it's an admission of guilt. I knew better as the professional that it needed to be fixed. So I'm going to be held liable. Is that the best approach of?
No, I think a waiver is absolutely great because, again, for example, in law, I cannot guarantee an outcome. It is actually unethical for me to tell a client or a potential client that I can win your case.
Mm-hmm.
I can say that, I feel confident based on the facts, etc. But I have to tell them right in my agreement that I cannot guarantee it. Because there's a lot of factors that go into that.
Yes.
So in your situation, what I would do is not only the waiver, but putting down that you advise the client. In the waiver, the client and I, discussed that they need to really redo portions of their slab, and it needs to be leveled out in order for their floor to be 100% perfect. And the client declined to do that. And you basically what it reads is Joshua Turner, the client, it was in. Let me make this simple. I, Joshua Turner, have been advised that the contractor is recommending, that my floor, that there be additional concrete poured or additional leveler or something to make the floor level. And I have decided to not do that and proceed with the installation without that. And I am hereby, having been advised of this, I am waiving any claim or defect against the contractor that may arise because I did not, have the floor leveled.
Okay. It's all in how you write it.
Yes. So the waiver is great, but include, that you told them.
Mm-hmm. Okay. So it is possible. It's not that it's bad information. I'm more for if I'm going to do the job, I want to do it right. And so that would be my question is, when can I break a contract? Can I end it at I don't feel that I can end it at any time, but if I tell you that I feel your floor needs to be flattened, otherwise I don't feel comfortable installing the flooring because I don't think it'll be successful and I don't want to put my name on it. Is that a good way to say this contract's null and void now because you don't want to proceed my way?
That will depend on how you again have your contract. If you put in there a cancellation clause that says, the contractor may cancel this due to impracticability, due to impossibility, or, something like that, then you're covered because let's say you can't get the flooring material.
Mm-hmm.
You contracted for the job, but now all of a sudden that material is no longer available. That's impracticability, or I'm sorry, impossibility on that one. Okay. You can't get it. So you can cancel the contract for that. Let's say that, you bid that project, and it was bid at $10 a square foot. Well, now overnight, we are involved in another war with the country that produces most of the material for that product, and prices have shot up to $50 a square foot. That the courts are not going to hold you to that contract. That is called impracticability. It is impracticable for you to be able to fulfill that contract because it would essentially bankrupt you. You could also have a clause in there that says, if a client does not sign a change order that is, pertinent to the job being done, then we can cancel. And then but then you also want to have information in there about what, how that works out in terms of what you've been paid and the work done and how that's, so yes, in short, to answer your question, you can absolutely have cancellation clauses in there for any number of reasons, but that's where the attorney comes in, discuss it with the attorney, and have those specifics in there and what that looks like.
Okay. No, I think that's great advice is you can get a waiver, have an attorney write it for you so that it's ironclad and you're not going to be held liable. Get a contract, talk over all the crazy situations you've ever been through, and then go talk to 5 other contractors, in my opinion, and ask them about all the crazy situations they've been through, and then talk to the attorney about adding all these kinds of crazy things into the contract so that you're protected, because you're not going to experience everything, and I would get a wide range of what about this, that, or the other thing. And although Josh is probably very familiar with multiple different businesses, you may bring up something that he hasn't heard yet or considered, and so you might be able to add another thing in there, and you're not taking up that much more of his time by you doing a little research on your side and trying to add in some things that may not be part of. I'm sure you have a standard contract, I would assume, at this point, and then you have a conversation and you button it up a little bit.
Exactly. And that's where, again, if you come to me Kyle, if you came to me and said, Josh, listening to you, talking to you, I realized my contract doesn't say what it needs. I need a contract.
Mm-hmm.
We prepare a contract for you, and you go through all that. Maybe 6, 7 months later, you come back and say, Josh, hey, we need this, included. And then it's simply amending your contract. And that's a lot, pretty straightforward and inexpensive. The last thing I really want contractors to understand, and Kyle, you said, mainly it's you. A lot of in terms of you doing the projects, a lot of contractors like to treat people as 1099 employees.
Yes, they do.
A 1099, and let me differentiate. A 1099 is not an employee. A 1099 is an independent contractor.
Yes.
Kyle, under your license as a flooring contractor, if you are using 1099 contractors, guess what? They have to have their own license. Yes. Or you are hiring an unlicensed subcontractor. So, and there are benefits to having, independent contractors versus employees. But here's the rule for independent contractors. You cannot control when or how they work.
Yep.
You can control the ultimate job project and tell them, hey, you're on this job, you're on that job. But by dictating the specifics of the job, that they're going to be there at 9 a.m. and work until 5 p.m., that they're going to use this material and that and this, etc. They are an employee. And it is imperative for companies to, make that distinction between employee and 1099, or you are going to have trouble with the IRS.
I wish that was true, sir. I really do. The construction industry is just plagued by this, and you've hit a sweet spot. And this has been a topic on this show before. And I wish there were more consequences. I wish that I felt that the ROC in Phoenix or within Arizona was actually going to go punish unlicensed guys doing work over $1,000, including they don't have the resources. And it's so standard in construction now that it's almost, it's just washed over. It's sad.
And here's
it shouldn't
the thing
be.
Is, what happens is people get away with it until the homeowner finally, the one homeowner gets fed up enough and files a complaint.
Yes.
Or, as you occasionally hear on the news, the guy that's been doing this for years unlicensed, and it finally catches up to him, and now he's facing the 25 or 30 unlicensed contractor charges.
Correct. When it catches up, it's bad.
Yeah. I have to be licensed as an attorney. I can promise you that my licensing requirements for being an attorney are far more than what it takes to be a licensed contractor.
Oh, for sure.
Following law school, and I had to go through the bar exam. The bar exam is 2 days, 2 full days. The first day is 100 multiple choice questions. These multiple choice questions generally have a fact pattern that is 1 to 2 pages long. And the answers for each multiple choice answer can be a paragraph or more. After you survive the multiple choice questions, you come into day 2, where throughout day 2, you will ultimately write the equivalent of 6 essays on substantive state law that generally are going to be 2 to 3 pages apiece. Assuming that you survive that and get a passing score, then you go through the fun of what is called character and fitness. Character and fitness is, do you have the character to be an attorney? And they dig into everything.
Oh, I bet. Your
finances, your personal life. You think an FBI background check is intense? This may be more so. You are required to disclose and write down any contact you have ever had with any police officer or anything other than personal. So if you were a witness to an auto accident and your name appears in that report as a witness, you better disclose it.
Oh my gosh.
If your neighbor called the cops on you because you were being too loud, you better disclose that, because they will go to every police agency where you lived and they'll request those records. And if it comes back that you didn't disclose something that they have a record for, very good chance you might not get to be an attorney. And so my point in all of that is, get licensed. Quit being lazy, protect yourself, and get licensed. And you will have far more success if you take the licensing test to get licensed as a contractor. Yes, it's hard work. I'm not going to say it's not. I've looked at the test. I've guided clients through the test, but it is worth it.
I think depending on where you're going, some are probably more difficult than others. I didn't find the flooring one that hard. I also went to the company that lets you study on the computers, and I don't think they're actually in bed with the ROC and the state and whatnot, but they have all the questions on a computer, and you kind of just, I'm good at rote memorization, so it wasn't that hard. After like a week of doing it, 2 weeks of doing it, I was like, I'm like acing this or getting 2 wrong every time. Like I thought it was going to take me a month or more. And I went off and took my business exam and my flooring exam, and on my way I went. So there's help to get, but yeah, look, the licensing is cheap. Everyone thinks it's going to be expensive. I just had to renew like a month or two ago, and it was $300 to renew the license, $300 into the recovery fund. So it's like $600. There's 2 years worth of licensing. And I, if I wanted a bond, I think the bond's $300 a year, maybe $300 for the 2 years. It's not expensive. I opted to have a CD that sits there and accrues some interest. So I put the money up myself. And then you got to get some insurance, which is another couple grand a year. Like, it's not expensive to do it right, folks. It's not. And if you go all the way back to, I just want to say, go back to the beginning when you said, don't be a sole proprietor. It's not expensive to set up an LLC in most states. It's in Arizona. I paid, it's $35 to do it, and then I expedited it, so I paid $85, or it was $50, and then I added another $35. One of the two. Like, to get an LLC, plus I got to pay the newspaper to put it in there, I'm going to end up spending about $120 at the most.
Now, Kyle, you don't have to publish it anymore, right?
I did not know that. So that's okay.
Yeah, you don't have to publish it, so forget about that part.
All right. Well, there, I formed an LLC for $85 today.
Yep, they're going to email you in a few days and say you're good to go.
All right, cool. But
yeah, it all comes down to prevention and, ultimately whether you want to be successful, and it's the same in any field. If you're going to be successful, it's going to take hard work, time, and dedication. Mm-hmm. And part of that dedication, time, and hard work is laying that foundation.
I agree. You got to put in the time, the effort to learn to build it. And if it's a if it's a wobbly foundation, you're building it out of sand or sticks. Like, which little piggy still had a house when the wolf came by, right?
Yeah. And you're going to like me a lot more when you use me as prevention than if you have to hire me for a lawsuit.
That I would agree with. So I think that does it. Is there, you've hit on a couple extra things. Is there anything else that we should hit on real quick?
No, I think, again, just contract formation, having the professionals around you, and in this case, an attorney, that prevention. We're happy to help. Give us a call, Turner Law Firm. We love working with contractors, and being able to help a business grow. And part of that is making sure you have the structure in place to support that.
Mm-hmm, mm-hmm. Definitely. It's going to take a team of experts. So build your team, folks, no matter where you're at. If you are in the Phoenix area, I know some of my local buddies listen, turnerlawaz.com. You can go there, and you can service the west side, you service the east side, so you're covering the valley, which is very convenient. Folks, I thank you, Josh, for your time. Thank you, listeners, for tuning in. As I mentioned before, if you're struggling with the numbers, go to flooracademypod.com, check out the files section, and I've got some stuff over there to help you kind of dial in what you need to be charging, why you need to be charging it, so you feel good going into a bid. I remember early on, I didn't know why I was doing what I was doing. I just knew I needed to make some money, and I was like wishy-washy. I'd negotiate more. Go in, know what you're doing, feel confident about it. If you're enjoying the show, if the show has helped you in any way, visit patreon.com/flooracademy. $5 a month goes a long way in helping me to continue to produce the content and make this all happen. Keeps the lights on around here. My wife enjoys having the lights on. So do I won't lie. My kids, they could probably do without it. They don't need those electronics anymore, but you know, help me out, folks. I'm here helping you. Help me, help you more. Thank you to the sponsors, International Surface Event and Johns Manville. And that's going to do it for us this week. I'll catch you all next week. Joshua, thanks again.
Thank you, Kyle.